Thank you, Mr. Parker. Ms. Snell?
May the people call their first witness?
Yes.
The people call Mr. Emery Winkle.
Be seated. All witnesses are assumed sworn. You may proceed.
Good afternoon, Mr. Winkle.
Good afternoon.
Would you please introduce yourself to the jury?
Hello, my name is Emery Willow Winkle.
Now, I'd like to begin with the events that occurred on May 1st, 2003. What were you doing that evening at around 11:30 p.m.?
Well, it was my birthday that day, and I had invited a lot of people to join me at my place of work, but it ended up being more of a private event. Nobody showed up, so I was cleaning up by myself.
What happened after you were done cleaning up?
Well, I decided it would be good for me to get some fresh air, so I step outside and I saw a woman some distance away from me at the end of the beach.
What did the woman do?
Well, she just seemed to be warming herself by a bonfire. And then a man came.
What did the man do?
He stabbed her. I saw him stabbing the woman with something, and then he ran away.
What did you do after you saw that man stab her?
Well, I panicked. I got very nervous, and I started breathing very hard, and I didn't know what to do, so I gathered up my courage, and I ran over to see if I could help.
Could you help?
No. As soon as I saw that body, I felt like there was nothing I could do, so I started panicking even more.
Now, Mr. Winkle, how do you know the defendant, Parker Jones?
Oh,
Objection, Your Honor. This question assumes fact, not evidence, that this witness does in fact know Parker Jones.
Sustained.
How, if at all, do you know Parker Jones?
well, that's the detective who came to me and tried to talk to me about what I saw.
You see him in the courtroom today?
Yes.
Could you identify him by what he's wearing, his location in the courtroom?
He's sitting at the end of the table to my right. He's wearing a tie, and he has glasses.
Your Honor, may the record reflect that this witness has identified the defendant?
Yes.
Now, you mentioned that he came to your home on May 2nd. What did you discuss that day?
Well, he tried to ask me if I saw the person who had stabbed that woman.
And what did you say?
I said no. He was far away. I couldn't really tell. It's medium build, medium height. Looked like he had medium weight. I told him I just wasn't sure.
And what did he say when you told him you weren't sure?
Well, he said that maybe if I thought about it a little more, then I might remember the face.
And what did you do?
Well, I said I could think about it some more, but I didn't think that I knew the person.
And after the second time you told the defendant you didn't think you knew, what did you do?
Well, then he had a picture. He had a picture of a man that I recognized.
Your Honor, may I approach the witness?
Yes.
And may the record reflect I'm showing this picture to opposing counsel?
Yes.
Mr. Winkle, I'm showing you a photograph pre-marked as Exhibit 4. Do you recognize it?
Yes, I do.
And what is it?
This is the picture that the detective showed me on May 2nd.
Your Honor, the people offer Exhibit 4 into evidence at this time.
No objection at this time, Your Honor.
Now's the time.
Yes, Your Honor, no objections.
Exhibit 4 is admitted.
May I publish this exhibit to the jury?
Yes.
Now, when he showed you this photo, what, if anything, did the defendant say?
He said that man was Matthew Reese. And I knew Matthew Reese. He would sometimes come around the restaurant where I worked.
Did he say anything else about Matthew Reese?
He said that Reese was a dangerous man. He said that he was no angel, that he had been convicted before of hurting people, of attacking a woman on a beach.
And when the defendant told you Reese had attacked a woman on the beach, what did you say?
Well, I said, that's very bad. But I still wasn't sure if that was the man that I saw.
Did you see the defendant the next day, May 3rd?
Well, yes, I did. I remember that it was the middle of the night, and he banged on my door, and he got me to open up.
And what did he say after you opened up?
Well, he said that they knew it was Reese, but that there was a problem, that they had found the woman's necklace in Matthew Reese's tent on the beach, but that a rookie had picked it up and got her fingerprints on it, and then they couldn't use that evidence.
And what did the defendant do next?
Well, he took that necklace and he gave it to me. He put it in my hand and he said, "You don't want a murderer to go free, do you? You think long and hard if that was Matthew Reese stabbing that woman."
Your Honor, may I approach the witness?
Yes?
May the record reflect I'm showing Exhibit A to the opposing counsel?
Yes.
Now, Mr. Winkle, I'm showing you an object pre-marked as Exhibit A. Do you recognize it?
Yes. He put it in my hand. This is the necklace that he said belonged to that woman.
Your Honor, may I offer Exhibit A to evidence at this time?
Your Honor, we do have a chain of custody issue with regards to this necklace. May I explain?
Yes?
Your Honor, Stipulation 8 states that Exhibit 8 was given to the FBI on December 24th of 2015, and they maintained it until trial today. But there's still a 12-year gap from when Mr. Winkle was allegedly given the evidence to December 24th, 2015. There's no foundation about that yet.
Ms. Snell?
Your Honor, Your Honor, Mr. Winkle just testified that this is the necklace the defendant gave him. There is no chain of custody issue because Mr. Winkle has authenticated this necklace. Opposing counsel's argument goes to the weight of the necklace, not the admissibility.
May I respond?
No, I'm going to overrule the objection.
Your Honor, may I publish Exhibit A to the jury at this time?
Yes. And
after the defendant told you Matthew Reese was a guilty man and gave you this necklace, what did you do then?
I looked at the necklace and I thought I didn't want a guilty person to go free. So I thought about it again and again and again. I thought, maybe it was. I didn't see him, Bishop. Maybe it was. Maybe it was Matthew Reese who had stabbed that woman.
Did you tell the defendant that maybe it was Reese?
The next day he came back and he said, "You know now," I said, "Yes, I'm pretty sure. I'm pretty sure it was."
And what did the defendant do when you said you were pretty sure?
Well, he said, "Pretty sure is not good enough. We need to get this guy. We need 100%. You have to be 100% sure that this man killed that woman."
Let's fast forward to December 23rd of 2015. What, if anything, did you find out about Matthew Reese?
Well, I was watching a documentary on TV and I got a bunch of texts. And everybody was saying that Matthew Reese didn't do it, that he was exonerated, that it was the woman's husband instead.
And what, if anything, did you receive the day after you found out Matthew Reese was innocent?
I got a text from the detective.
What did that text
Objection,
say?
Your Honor, lacks foundation that it was from the detective himself and not just the detective's phone.
Sustained.
Your Honor,
Motion
may I
to
be
strike.
heard?
Can you lay that foundation?
Your Honor, Stipulation 9 is that Exhibit 9 displays text messages sent on December 24th from Parker Jones' cell phone to Emery Winkle's cell phone.
Can we link that up to Exhibit 9 and we make sure this witness is referring to Exhibit 9?
Yes, Your Honor.
Okay, so I'm going to withhold ruling until we've given counsel a chance to lay that foundation, but right now that evidence is not it.
Yes, Your Honor.
Okay.
Your Honor, may I approach the witness?
Yes?
May the record reflect, I'm showing Exhibit 9 to the opposing counsel.
Yes.
I'm showing you a photograph pre-marked as Exhibit 9. Do you recognize it?
Yes, I do.
What is it?
This is the text that I received from Detective Jones's phone.
What does this exhibit say?
It says,
Objection, Your Honor. I'd ask that the opposing counsel wants to read this, it be entered into evidence.
Are you offering Exhibit 9?
Yes, Your Honor.
Do you have an objection to its admission?
Yes, Your Honor, to 401 as to relevance and to 403 as to misleading the jury.
Okay, what's the relevance?
Your Honor, this text is highly probative. It says we need to stick together and we need to stick to our story. Now, take note of the wording. We is the defendant's admission that he was involved in Mr. Winkle's false testimony. And story suggests that the defendant knew his testimony was not the truth. It shows the defendant intended to influence Mr. Winkle's testimony in 2003.
Response?
Yes, Your Honor. The charge here today is about May of 2003. This text was sent in December of 2015. Now, beneath what opposing counsel read on that text, it says, or else. That would be interpreted as a threat. Because there's this alleged threat in this text from 2015, but that can in no way go to the defendant's guilt or innocence on this charge, it's misleading to the jury to enter this into evidence because it's from 2015, not 2003.
How is that not circumstantial evidence of the defendant's knowledge of guilt or belief of his own guilt, or an evidence of the defendant's intent to cover up a crime?
Your Honor, it may have some probative value as to the factors Your Honor just discussed. However, it's the defense's position that the prejudicial effect of misleading the jury outweighs that probative value because of the threat that this text contains and because threat is part of the 2003 charge. There's a confusing of the issues.
Ms. Snell?
Your Honor, first of all, no foundation has been laid that people are using this as a threat. And second of all, Rule 403 states that evidence must be substantially more prejudicial than it is probative. This text is highly probative, and therefore any prejudice that it has isn't enough to make it inadmissible.
Last word?
I stand by my argument, Your Honor, that it confuses the issues by having a threat in 2015 when threat is part of the charge in 2003.
The objection is overruled. Exhibit 9 is received.
Now, Mr. Winkle, what did this text say?
it said that it was Detective Parker and that we needed to stick together, we needed to stick to our story, or else.
May I publish Exhibit 9 to the jury?
Yes.
Mr. Winkle, did you testify in 2003?
I did.
What did you say?
I said what the detective told me to, that I was 100% certain that I had saw Mr. Reese stabbing that woman.
Thank you, Mr. Winkle. Your Honor, no further questions at this time.
Cross-examination, proceed. Good afternoon, Mr. Winkle.
Hello.
Mr. Winkle, on direct examination, you said that on May 3rd, Detective Jones told you that a rookie cop had found the necklace, Exhibit 8, right?
I think so, yes.
And you said that Detective Jones told you that that necklace had the rookie cop's fingerprints on it, right?
He said that it was tampered with, that they couldn't use it, that's right.
You said on direct that it had the rookie cop's fingerprints on it. Yes or no?
I don't know if the fingerprints were on it, but that's what I said, that's what he said.
Your Honor, let the record reflect that I'm handing opposing counsel a copy of this witness's sworn affidavit. Would Your Honor,
record will so reflect?
would Your Honor like a copy?
Not at this time, thank you.
Permission to approach the witness?
Yes.
Mr. Winkle, I'm now handing you a copy of your sworn affidavit. Do you recognize that?
Just 1 second.
Of course.
This is my affidavit.
And that's your signature on the 3rd page, right?
That's my signature.
You were truthful and accurate when you composed this affidavit.
Absolutely, I was.
You include all facts relevant to today's case.
Yes, that's what you told me to do.
Mr. Winkle, could you please point the court to exactly where in this affidavit you say Detective Jones told you that his rookie cop's fingerprints were on the necklace?
No, I say the Turner's necklace was found in Reese's tent a mile down Roma Beach from the location of the murder, and the necklace had Karen Turner's fingerprints. But Jones said the police couldn't use the necklace against Reese because a junior officer had searched Reese's tent without a warrant. And then Jones pulled the necklace out of Jones's pocket, pressed the necklace into my hand and closed my hand around it, and he said, "This was Karen's. I don't want a murderer to go free because my rookie cop forgot to get a warrant. We need an eyewitness." That's what he said.
Mr. Winkle, I appreciate that answer. But if I could direct you back to my original question. Did you, anywhere in that paragraph, just read a quote from Detective Jones saying that his rookie cop's fingerprints were on the necklace? A simple yes or no.
No, he said Karen Turner's fingerprints so he couldn't use it, and the rookie cop searched Reese's tent. That's what he said.
So when you said that the rookie cop's fingerprints were on it, you were mistaken on direct.
I suppose I was. It was Karen Turner's fingerprints.
Right, no, Mr. Winkle, you testified at the trial of Matthew Reese in 2003, right?
That's correct, yes.
You testified that Matthew Reese was a killer.
That's correct. That's what I said.
And after your testimony, Matthew Reese was convicted.
That's right.
No, Mr. Winkle, as you testified on direct, it was December 23rd of 2015 that you learned that Matthew Reese had been exonerated, right?
That's true.
That day, or excuse me, the next day, when you walked outside your home, there were media on your front lawn, right?
That's right. A lot of people were there. They were yelling at me and asking me questions, and I told them that I made a mistake and that I didn't want to talk to anybody.
Exactly. The words you used on December 24th were mistake, right?
I said that, yes.
So at that point, on December 24th, did you ever claim to have been pressured by Detective Jones?
On December 24th, yes, I did.
But at that point, Mr. Winkle, when the media were on your front lawn,
No, the only thing I said to them then was, go away, I made a mistake, I needed to be by myself. It was a little later that the FBI came, and I told them what happened about my being coerced.
okay, and after the FBI were in your home, you were in meetings with a federal prosecutor, yes or no?
That's correct.
And after weeks and weeks of those meetings, you agreed to testify against Detective Jones, yes or no?
Not after weeks, no.
Not after weeks? Could I direct you back to your affidavit? I'd like you to turn to page 2 and read silently as I read aloud. Excuse me, page 3. Over the next couple weeks, I met repeatedly with the FBI and then a prosecutor from the United States Attorney's Office, and they eventually asked me to testify against Detective Parker Jones. Did I read that correctly?
That's correct. It was a couple months until they asked me, not just a few weeks.
Okay, so many weeks.
Yeah.
And Mr. Winkle, in exchange, you were promised by the U.S. Attorney that you would not face prosecution for your 2003 testimony if you testified against Detective Parker Jones.
I think they told me that.
Objection. Hearsay?
As to the statements from the government
Yes, Your Honor.
response?
Your Honor, we're not offering these for the truth of the matter asserted, that he would actually be immune from prosecution, but rather for the effect on the listener and his bias in today's case of testifying against Detective Parker Jones.
Submitted if it's not being offered for the truth.
Proceed.
Around this time, Mr. Winkle, you were receiving hate mail, right?
Yes, a lot of hate mail and death threats and some very nasty things were being said about me.
And you didn't want to be blamed for what had happened to Matthew Reese, right?
I accept that I have some responsibility for what happened to Mr. Reese. I accept that.
Mr. Winkle, again, I appreciate that answer, but that wasn't quite my question.
I'm sorry.
You did not want to be blamed for what happened to Matthew Reese, is that correct?
Well, I've accepted that I bear some responsibility for what happened.
But when you were talking to the FBI, you didn't want to be blamed, right?
Of course I didn't want to be the only person when I was coerced, but I do accept some responsibility. That's why I'm testifying today.
And prior to the meetings with the FBI, did you ever tell anyone that you had been pressured by Detective Jones?
I don't have a lot of people to talk to generally.
Mr. Winkle, do you believe you have an accurate recollection of what happened in May of 2003?
For some of May of 2003, what happened on that night, everything was happening so fast. I felt like I was under a lot of pressure. An officer later told me that I had gone into shock. I don't remember that night, May 1st. I don't remember that night so well.
Well, in 2003, when you testified in court, you said you remembered that night pretty well, right?
I said what he said. I said 100% because that's what he wanted.
Mr. Winkle, can you tell this court how many times you remember Karen Turner being stabbed in 2003?
It all happened so fast. I think it was one time. But it all happened so fast.
Your Honor, let the record reflect that I'm handing opposing counsel a copy of what has been marked as Exhibit 1.
The record will so reflect.
Permission to approach the witness?
Yes.
Would Your Honor like a copy?
Thank you.
Oh, Mr. Winkle, I'm handing you what has been marked as Exhibit 1.
Yes.
I'd like you to turn to page 3 of that exhibit. Excuse me, page 2.
Oh, yes.
That's your testimony there?
Yes, this is what I said.
On line 27, you said twice with regards to the number of stabs, right?
I said what I was told to, yes. I did say twice.
Is it your testimony you were told to say twice?
I did what the detective wanted.
Is it your testimony you were told to say twice?
He said we needed to get this guy.
Thank you, Mr. Winkle. Your Honor, no further questions. We'd like to admit Exhibit 1 into evidence at this time.
That's one of those the parties agree is admissible, is that right?
Yes, Your Honor.
Exhibit 1 is received. Thank you very much. And as I understand it, Exhibits 1 through 4 and 7 through 9 are admitted. Is that my
Yes,
understanding
sir.
correct?
That's my understanding as well, Your Honor.
Great.
No
Will you
further
be-
questions. May this witness be excused?